Welcome, esteemed guests, colleagues, and especially students. I'm Lucy Winskill. I'm the Pro-Vice Chancellor here at Northumbria University for Region Engagement and Partnership. But in my former life, I was a solicitor for 25 years. I still have a practising certificate. Very involved in Law Society matters locally as Newcastle Law Society President and nationally on the Law Society Council. And more recently, I lost all of my friends in the law overnight by joining the board of the Solicitors Regulation Authority, because people don't have a loving relationship at all times with their regulator. But because of that background, I was absolutely delighted when the law school asked if I would introduce this particular lecture, the third in our series of the Eldon lecture series, and with the background as a lawyer, very particular pleasure to welcome our guest, who I'll introduce briefly in a minute. These lectures bring together high-profile judges, lawyers, academics and policymakers into the university to inform, educate and provoke students and our faculty members and the profession, and we're pleased to welcome so many guests tonight. I am delighted, as I say, that this particular lecture is to be delivered by the Solicitor General. Edward Garnier QC, MP, was born in Germany, the son of a British Army colonel. Edward read history at Oxford before transferring over to law and was called to the bar in 1974, specialising in defamation law and taking silk in 1995. He was appointed a Crown Court Recorder in 1988 and a bencher of the Middle Temple in 2001. He's also been a Member of Parliament for Harborough since 1992. He has a very long and keen interest in justice issues while serving as an MP. He was PPS to Sir Nicholas Lyell QC while he was Attorney General, was frontbench spokesman on the Lord Chancellor's Department under William Hague, and was Shadow Minister for Justice and Shadow Attorney General. He was appointed Solicitor General in May 2010 under the coalition government and co-chairs the Attorney General's Pro Bono Committee. The Solicitor General's speech is entitled Pro Bono Legal Advice, Giving Something Back. It will address the importance of pro bono lawyering and the benefits this can bring for clients and the profession. And this speech is timed to coincide with the launch of an exciting new initiative, the North East Pro Bono Hub, more of which later. The Solicitor General's speech is likely to last for about 30 minutes, and following that, my colleague Kevin Kerrigan, Dean of the School of Law, will give the vote of thanks, but sadly, immediately after that, the Solicitor General must leave us to catch a train back to London. But we are very grateful indeed that you spent so much time with us today and with our students. Kevin will then introduce a panel discussion about local pro bono initiatives. So without further ado, it gives me great pleasure to introduce Edward Garnier QC MP, our Solicitor General.
Well, thank you very much, Pro-Vice Chancellor. I have a confession to make. When I took silk in 1995, my daughter, then aged 12, decided that QC didn't mean Queen's Counsel. I thought it meant quite clever. She decided it meant quite a clot. And so that's who you've got this evening. It's a great pleasure to be here in Northumbria this evening to speak to the present and the future generation of the legal profession. And I want to first of all thank you, if I may, for inviting me along with your colleagues in the law school. Whether you'll thank any of them for doing so by the end of this talk is quite another matter. 30 minutes seems an awfully long time. Certainly seems that to me. I think it's also pretty cruel of the university to arrange this talk in a room where the exits mean that you have to get past me in order to get out. I think the safer course is to have a quiet slumber while I waffle on. I will talk a bit about pro bono, but I want to also talk about other matters as well. And I hope that you'll tolerate my warbling. Our constitution, the English constitution, is full of old and strange jobs and titles, like that of the Attorney General and my own, the Solicitor General. And to most people, even those with knowledge of the government and the criminal justice system, the role of a law officer is something of a mystery. So I'd like to say a few words, if I may, by way of general introduction, about the offices that Dominic Grieve, the Attorney General, and I, the Solicitor, hold, and the work that we do. I confess that I'm neither a solicitor nor a general, but I'm working on it. But then two of my ancestors, way back in the reign of William and Mary, they were apothecaries general to the army, and they weren't apothecaries or generals either. So there we are, a strange place to begin. As I indicated, the office of the attorney is a very old one. Legal historians disagree about the exact date and who precisely was the first Attorney General. But there are records that point to someone called Lawrence Stilbrooke being appointed to sue the King's affairs of his pleas before him in around 1247. And William Langley, who in 1315 was designated as the first King's Attorney. The first of whom we have a portrait in the Attorney General's office in London, in Victoria Street, is somebody called Sir William Hobart, or Hubbard. And that is in 1485. He's in full armour and brandishing a sword. Fortunately, the armoured part of the job is no longer quite so necessary, although given the way the role has changed, it really is debatable whether they were in any meaningful sense like the Attorney General of today. Now, if some of my predecessors have not achieved fame, although those of you who've been watching Garrow's Law on Sunday nights on the telly will know at least one of them, after all this good stuff, the friendly pro bono stuff he does, he then eventually went on to become a pretty severe Attorney General. One of my predecessors managed to achieve a degree of infamy. He was called John Cook, and he was the first Solicitor General of Oliver Cromwell's English Commonwealth. And he led for the prosecution, if that's the right way of putting it, in 1649 in the trial of King Charles I. Now, unfortunately for him, the tables were turned after the Restoration, and his reward for having carried out his duties were to be found guilty of high treason. He was hanged, he was drawn, and then he was quartered. But so far, I think he's the only law officer to have met that particular fate. History may yet reveal others. Well, if he does nothing else, his fate gives us pause to think about the cab rank rule, which requires barristers to take the next case, irrespective of the client's charms or predilections. That said, I'm not even sure that my ancestor, William de Grey, who was between 1762 and 1781, successively Solicitor General, then Attorney General, and then Lord Chief Justice of the Common Pleas, would recognise the office today. He suffered so badly from gout in his hands and fingers that he could not hold a quill to take a note of the evidence or the arguments. And yet, I understand that as a judge, he delivered some extempore judgments after lengthy civil trials that better historians and certainly better lawyers than I tell me would pass muster in today's higher courts. I've inherited his pride in being a law officer. I've also, sadly, inherited his gout, but perhaps not his intellect. In any case, what history has bequeathed us is an Attorney General who's a Minister of the Crown and Chief Legal Advisor to the Government. He also exercises a number of functions in the public interest. He superintends the Crown Prosecution Service and the Serious Fraud Office, and he oversees the Government Legal Service. Now, the Attorney and I are politicians. We're members of the government. We're Conservative members of Parliament. But the Attorney is not a member of the Cabinet, though he will attend when his advice is required or when matters within his responsibility come up for consideration. The Solicitor is essentially the Attorney's deputy, but since the Law Officers Act of 1997, any function that the Attorney can exercise can also be carried out by the Solicitor. So in law, at least, we are equals, and indeed we share much of the work that falls to be done in the name of the Attorney General. So when I talk of the functions of the Attorney General, I also talk of the functions that I carry out as well. There's a third United Kingdom law officer, and that's the Advocate General for Scotland, and that's currently Lord Wallace of Tankernas. He is responsible for advising the United Kingdom government on matters of Scots law, though the three of us share much of the work in advising the government on other matters as well. I'll just say a little bit, if I may, about the role of the law officers as chief legal advisors to the government. This was neatly summed up by a former Attorney General in the 1980s, Lord Mayhew, Paddy Mayhew, who will be familiar to many of you. And he said this: "The Attorney General has a duty to ensure that the Queen's ministers who act in her name, or purport to act in her name, do act lawfully, because it is his duty to help to secure the rule of law, the principal requirement of which is that the government itself acts lawfully." These days, the role is reinforced by the ministerial code issued by the Prime Minister, which requires the law officers to be consulted in good time before the government is committed to critical decisions involving legal considerations. Government departments will often come to us for advice on how policy can be achieved in a lawful or proper way. And by long-standing convention, also recorded in the ministerial code, neither the fact that the law officers have advised or not, nor the advice that the law officers have given, may be disclosed. What this means is that the public only see the capital ships, dressed fore and aft, steaming full ahead on the high seas, occasionally firing their guns and just from time to time at each other. All the while, below the surface and silently, and known only to a few in the law and in Whitehall, lurk the two submarines, HM Attorney and HM Solicitor. But our time is not spent only saying no, but also, and this is perhaps of some interest to those of you working in the law firm upstairs, we also say, have you thought about doing it this way? Which is what I suggest all good lawyers should do for their clients. Now, one aspect of this role is that we are the political and the legal heads of the government legal service. And we enjoy a special relationship with the lawyers in every other government department, which entitles them to consult us on legal issues affecting their advice to ministers, as well as where different departments have differing views on some issues that need to be arbitrated. We seek to preserve the professional independence and ensure high standards of advice and professional conduct in the departmental lawyers. Of course, many of the legal issues that policy development gives rise to never come anywhere near the law officers, but we remain the protectors of the rule of law, and we ensure that the government and its ministers conduct their business within the law and with propriety. And in that role, we are ourselves lawyers, but not just lawyers. As politically appointed ministers, who are also lawyers, we don't give advice or lead our lawyers with party political bias, nor do we adjust our advice to suit our party's narrow political interests. But because we are appointed and accepted as fellow ministers, as fellow members of Parliament, as elected politicians, we can speak to our colleagues in government, from the Prime Minister downwards, with a confidence, with a directness, and with an understanding of the environment within which we operate. We are there to speak truth unto power, and if we don't do that, we are failing in our job. It is a role that has taken on a new importance now that the Lord Chancellor is no longer the head of the judiciary, but the head of a large spending and political department. Increasingly, we are seen as the link between government, Parliament and the bench, as well as the legal professions. And the same, to some extent, goes for government lawyers in their departments. But they have the comfort, at least I think they have the comfort, of knowing that if their advice is questioned or improperly criticised, they can come to us for protection or may consult us if they have doubts about the propriety of any proposed course of action in a matter for which they have responsibility. This means that they can discharge their role in their respective departments, and it's a role that reflects ours at their head, not as politicians, but as government lawyers who are also independent professionals. We also have a role in the legislative process, considering each bill as it approaches introduction. And although we aren't members of the Cabinet, we do sit on the various Cabinet subcommittees, like the Parliamentary Business and Legislative Committee, which considers the readiness for introduction of most government bills and authorises their introduction. In that, the law officers assist the government in its search for a lawful and proper way to achieve its policy objectives. Ultimately, we can block a bill if we have unresolved concerns about its legality or its propriety. But our ability to ensure that bills are legal and proper comes from our relationship with the government lawyers who work on bills and with the Parliamentary Council who draft them. The role of Parliamentary Council as the drafters of legislation is central to this process. Parliamentary Council advise government lawyers on matters of legal propriety as they draft a bill and refer matters of concern to the law officers if they can't be resolved. And these briefings also serve as a useful guide to the law officers to new trends in drafting and legislation, for bill work is not immune from innovation. Governments legislate to meet or influence events which throw up new challenges that have to be met. However, we need to ensure that the legislative responses to those challenges are appropriate and that the government's understandable desire to act does not lead to ill-considered or inept legislation. I leave it to you how successful we have been in that regard. Parliamentary Council and government lawyers enable us to check this and to offer a guiding hand if we feel that an excitable and excited minister has been touched by a bout of unlawful enthusiasm. The volume of legislation in recent years has been relentless, and whether it has been of any public benefit is, as I indicated a moment ago, entirely a matter for you. If we are to legislate, at least we should make good law. We have a more direct role in relation to the compatibility of proposed legislation with the European Convention on Human Rights. When a bill is introduced, the minister in charge in each house is required by Section 19 of the Human Rights Act to make a statement that, in his or her view, the bill's provisions are compatible with convention rights. And you'll see that on the face of the bill. I'm sure those of you who've seen an Act of Parliament will have noticed that. Alternatively, if the minister is not able to provide that personal assurance, then he or she must state that, nevertheless, the government wishes the House to proceed with the bill. We will consider and clear the human rights memorandum the departments are required to produce for the Parliamentary Business Committee. And this memorandum sets out an analysis of the convention rights that are engaged by the bill and an assessment of any inferences and interferences and justification for them in convention terms. The department demonstrates its human rights law reasoning with a view to satisfying the law officers and so the committee and thus the government that the route by which the department has come to the conclusion that the bill is compatible is correct. We say, perhaps a little too glibly sometimes, that the core function of the law officers is to make sure that government and ministers act lawfully, in accordance with the rule of law. Some of you may find it harder to accept that a politician and a member of the government is best placed to ensure that the government acts lawfully in everything that it does. Some argue that the current office involves too many conflicts of interest. These opinions have been examined and argued widely in the recent past. In fact, there were suggestions that the role should be scrapped altogether, that the Director of Public Prosecutions, the DPP, should be set free, and that we should have a civil servant as the government's chief legal advisor. Now, that model was examined at length, but the role was settled in 2009 under the last Labour government, following a thorough review and the production of a protocol, and it was agreed with the prosecuting departments. It set out how the relationship works in practice and safeguards the independence of the prosecutors while enabling the attorney to be properly accountable to Parliament and to the public. Clearly, I'm glad that the role was realised as being better kept as it is, not only because of the accountability element, but also because as politicians, the attorney and I are more likely to be listened to by our colleagues and by Parliament itself, as we share the same aspirations, if not always the same opinions. But my job is not all about liaising with government. The attorney and I superintend and are responsible to Parliament for the Crown Prosecution Service, and I spent part of today visiting the CPS in St Anne's Quay here in Newcastle. We also superintend the Serious Fraud Office and the CPS Inspectorate. And you may want to know what I mean by the word superintend. Well, we don't run these bodies and we don't micromanage their day-to-day activities, but we meet regularly with the DPP and the Director of the Serious Fraud Office and the Chief Inspector of the CPS to discuss the overall strategy of their organisations. We also have an array of independent public interest functions which have been acquired over time. We consider where in the most contentious cases the public interest lies and how it could be best served. For example, referring cases to the charity tribunal, such as the private schools case concluded just a few weeks ago on the nature of the public benefit which independent charitable schools are required to provide. We consent or not to those prosecutions that require our consent. For reasons that are not entirely clear to me now, this includes any prosecution relating to explosives, and we refer to the Court of Appeal and frequently appear to argue about those Crown Court sentences that we consider to be unduly lenient. This power to refer what we may suggest are unduly lenient sentences is often thought of as a right for the prosecution or indeed an interested party to appeal against a lenient sentence. But that's to misunderstand the nature of the power and our role, which is to provide an exceptional remedy to address those sentences which fall below the range of sentences it was reasonable for the judge to impose, that they risk damaging public confidence in the criminal justice system. The attorney and I consider personally each case we are asked to look at, which comes within the scheme and is within the time limit. It's 28 days is the narrow time limit. We take advice, as you may expect, including from experienced independent counsel, Treasury counsel, but the decision is one that we have to take ourselves. And it's only where we feel that a sentence was significantly outside the appropriate bracket that we will ask the Court of Appeal to interfere. And it's then, of course, a matter for that court whether it decides to increase the sentence. I'll just give you a few examples. I recently referred a very unpleasant sexual assault case from Loughborough to the Court of Appeal earlier this year. And in that case, I felt that the Crown Court's sentence of 15 years was unduly lenient given the extremely violent nature of the attack and the need to protect the public. It was an utterly horrific attack. And I won't go into the factual details of it, but it was pretty hideous. The Court of Appeal accepted my submissions and instead imposed an indeterminate sentence for public protection. I've also referred cases involving burglars breaking into women's homes or into halls of residence at universities in the middle of the night, intending to steal, but who, on finding a sleeping woman alone, unprotected and vulnerable, then went on to rape and to humiliate them. I believe the courts have a duty to provide protection for women in their homes, and where the sentence is unduly lenient, I can ask the court to increase it. And in those cases, what I call the safe haven cases, the lead case was called Pio, which may be one that you've subsequently come to learn about, the Lord Chief Justice and the other judges in the Court of Appeal double the sentences from 6 and 7 years to 15. We also have a role which has recently acquired an increasingly high profile in prosecuting cases of contempt of court, so as to ensure that criminal trials are not undermined by prejudicial media reporting. When in private practice, I was instructed by a number of media organisations to advise on these sorts of cases. But these days, I am more of a gamekeeper than a poacher. Contempt can also be committed in other circumstances too, as was shown earlier this year in a case I prosecuted in the what used to be called the divisional court, in the administrative court, concerning a juror who had contacted the defendant during a trial via Facebook, revealing the jury's deliberations. The woman juror pleaded guilty to her contempt of court, and the Lord Chief sent her to prison for 8 months. I should emphasise that in this role, there's no desire to censor, but solely a need to ensure that a case is decided on the evidence that is presented in court. The right to free speech and open justice is fundamental, but at times can clash with another fundamental right, that to a fair trial. The contempt jurisdiction and the law officer's role in overseeing it is born of an attempt to strike the right balance between these two rights. In taking my oath as Solicitor General before the Lord Chief Justice in May of 2010, I said this, that I would truly minister the Queen's matters and sue the Queen's process after the course of the law and after my cunning. For any matter against the Queen where the Queen is a party, I will take no wages or fee of any man. I will duly in convenient time speed such matters as any person shall have to do in the law against the Queen, as I may lawfully do, without long delay, tracting or tarrying the party of his lawful process, in that to me belongeth. And I will be attendant to the Queen's matters when I shall be called thereto. Old words for an old office, but they are as relevant today as they were decades and centuries ago. 650 years ago, justices of the peace were introduced to this jurisdiction, another old and some might say quaint public office that adorns our eccentric constitution. We couldn't run our criminal justice system without the lay magistracy, who deal with well over 90% of the criminal cases that come before our courts. The need for justices of the peace, volunteers who give of their time in their local courts and to provide with juries in the Crown Court that democratic element that ensures public acceptance and consent to our criminal justice system, is, in my view, as great today as it has been at any time in their 6.5 centuries of existence. So we have JPs, we have High Sheriffs, we have Attorneys and Solicitors General, we have Lord Lieutenants, we have Vice Chancellors and Lord Mayors. We have them, and we have had them, for years. And in my view, these offices are old because they are good, valuable, and needed. They are not bad because they are old. They may sound unmodern, they may occasionally wear funny uniforms, but like so many institutions in this country, such as our universities, they perform a necessary public function, and we should celebrate them now and I hope for many years to come. In my approach to the role of Solicitor General, I've been much influenced by a former Solicitor and Attorney General, Peter Rawlinson, who was appointed Solicitor General by Harold Macmillan in 1962. He describes in his autobiography, A Price Too High, how he was invited to become Solicitor General by Macmillan. The Prime Minister honoured him, he said, with a scholarly review of medieval office holders, a review which flowed into the 16th and 17th centuries, embraced approvingly the career of Samuel Pepys, and concluded with the admonition that the loyalties of the law officer must be first to the Crown, second to Parliament, and only thirdly and almost incidentally to his administration. Now, I've always been struck by that order of priorities and that order of loyalties that Macmillan described, and I regard it as one which I now, a law officer, will honour for so long as I hold this office. I was appointed during a 5-minute telephone conversation with the Prime Minister, so there wasn't time for a scholarly review of medieval offices, something I'm sure that David Cameron is entirely capable of doing, but perhaps when he gives me the sack, he'll have more time. For my part, doing a job in government so closely associated with the law, which has been my profession and such a big part of my life for over 35 years, is a reward and an opportunity. I've never been a very political politician, unlike William Hague or Harold Wilson, who were clear in their early childhood. I didn't want to be a member of Parliament or even join the political party of my choice until I was about 30. Oxford was a time for books, but also for parties, for cricket, for rugby and for fun, and not the earnest pursuit of student politics. My 20s were spent in passing my exams, I did manage to do that, starting my career at the defamation bar in Brickcourt, and getting married, but not in politics. The life of the law officers, although circumscribed by limitations that a real politician would not tolerate, brings one to the very centre of power, even if those at the centre of it don't realise. It's not the dry and fusty world of the Dickensian lawyer's office, still less the office of circumlocution. But we are so often and deliberately the silent service. We don't publish our legal advice, we respect our clients' confidence, and like submarines, we are, as I said, most effective when working unheard and unseen. If we surface, that's when we're in trouble, or the government's in trouble. Now let me finish, and I promise I will finish, let me finish by saying something about pro bono. First, I was extremely impressed to hear about the book, A Student Guide to Clinical Legal Education and Pro Bono, written by Kevin Kerrigan, who's here, and Victoria Murray, including contributions from Cara Boothby, who I have the pleasure of meeting today, Caroline Foster, Johnny Hall, Judith Gowland, and Paul McEwen, all members of the law school here and who are members or staff of the legal clinic. This book provides sound guidance for students to help you set up your own pro bono projects. Participating in pro bono work will help develop the skills and the experiences that you will employ throughout your careers as lawyers. The former Attorney General, Patricia Scotland, Baroness Scotland, wrote the foreword, and she highlights the importance of this publication, and I completely agree with her. In 2006, only 46% of law schools in England and Wales offered students pro bono opportunities, compared to 65% in 2010. A notable improvement, and I hope that the graph continues upwards. As you may be aware, Dominic Grieve, the current attorney, and I, along with a good many legal practitioners from the bar, the solicitors and the legal executives professions, judges, academics, law students and people working for legal charities and NGOs, recently celebrated the 10th anniversary of National Pro Bono Week. A key highlight from the past year was that an additional 28 clinics have been added to the LawWorks National Support Network for free legal advice clinics, taking the number to more than 100. 8 were set up from scratch with the assistance of project staff. This is truly impressive, as I remarked during the course of the reception that we held in the House of Commons. We know that the number of pro bono opportunities being offered by universities is increasing, and it's clear that the number of lawyers acting pro bono is also on the rise. We also know that more and more lawyers first start out their pro bono work while students and continue their pro bono commitments well into their professional careers. Speaking to both lawyers and students, I can see that pro bono not only brings with it a sense of social responsibility, but also a tremendous sense of achievement and attainment. It reconnects lawyers with their desire to see justice done without making justice hang precariously on the cost of so doing. And it's something lawyers can do at all stages of their careers, and even after they've retired from practice. It says a great deal about the profession that in this financial year alone, it will provide over £500 million worth of legal services through the pro bono system. That's a huge number. So let me end by quoting Thomas Jefferson, who wrote to John Adams in 1816 and said this: "I believe that every human mind feels pleasure in doing good to another." Adams and Jefferson are two of my heroes, both American patriots, political allies and rivals, successive presidents of the United States, numbers 2 and 3. One was a lawyer and a farmer from Massachusetts. The other was a diplomat, a philosopher and landowner from Virginia. But both were very much men of their time, but ahead of their time, and who, after a period of estrangement, became firm friends towards the end of their lives, both dying, as it happens, on the 4th of July, 1826, the 50th anniversary of American independence. So let me ask you to do as they would have you do. Do justice in asking for justice, and take pleasure from doing good to others. It seems a fitting way to reflect the work that you are doing, and as Solicitor General, I will more than lend my support, I will heartily give my support in encouraging you to continue the excellent pro bono work that you do here in this building for the people of this city. Thank you very much indeed.